Welcome to ANA Investigates, a monthly podcast covering the latest in neurology and neuroscience brought to you by the American Neurological Association. I'm your host, Adeline Goss. This is an exciting time in the treatment of neurologic disease, a period of rapid innovation and discovery. And as a result, more and more academic neurologists and neuroscientists are partnering with the corporate world and others to bring their discoveries to market. Today on ANA Investigates, we'll explore the complex world of patents and intellectual property in academic neurology. I'm joined by Dr. Clifton Gooch, professor and chair of neurology at the Morsani College of Medicine at the University of South Florida. Hi, Cliff.
Hello, Addie. I explored this important topic with a colleague of mine, Dr. Terry Hunter, the Senior Licensing Manager of Technology Transfer at the University of South Florida Office of Research and Innovation. Dr. Hunter has a PhD in immunology and medical microbiology and previously worked as a research scientist in immuno-oncology before joining the University of South Florida Technology Transfer Office. Dr. Hunter, thank you so much for joining us here on ANA Investigates.
Thank you so much for having me here.
Can you start by telling us a bit about what you do in your current position at the Technology Transfer Office?
I'm responsible for basically what we call a cradle-to-grave approach with technologies. I meet with faculty members that have new compositions of matter, new treatment, new tests, new potential therapeutic devices, and I help them disclose that to our office. Then I search and determine if there's anything that's out there that's relevant. I look at the novelty of those inventions, and then I decide whether or not to move forward with patent applications. During the patent prosecution process, I work with outside patent counsel to help navigate the patent prosecution. And then I help to also put together marketing materials and to market the technologies. And then once we find an interested commercial party that wants to interact or get into a license agreement related to that technology, I negotiate those license agreements, and then I manage that agreement for the life of the patent.
So, Dr. Hunter, could you give us a bit more detail about the history of intellectual property in biotech?
Sure. There was a landmark case called the Bayh-Dole Act, and this was in 1980. And this really laid the foundation for current tech transfer and biotech. This was enacted in December of 1980, and it created a uniform policy amongst all the federal granting agencies. And it allowed any nonprofits or universities or other public institutions that were receiving federal government grants to be able to apply for their own patents. So, for example, the University of South Florida, if research is federally funded, the university is able to still have an ownership interest in that patent and be able to file for patents on federally funded research. Now, in return, the universities are encouraged to collaborate with commercial concerns to promote the utilization of these inventions. So there is an obligation in return to receiving this federal funding that we do try to transfer this technology out of the university to the citizenry. We're expected to file patents on the inventions, and we're expected to give licensing preference to small businesses. So that's why you'll hear universities frequently talking about startup businesses or spin-outs, because we're encouraged to actually have an economic influence and starting new companies around these technologies. Now, biotech itself is more interesting. There's been some ups and downs in the patent landscape over the last several years. The first really relevant case, I think, also came in 1980, where a gentleman had created a bacteria that could reduce or be utilized to break down crude oil. And the company he worked for, which is General Electric, applied for a patent application, and the patent was denied. The examiner said, this is a living thing. It's not novel, it's not new, therefore it's not patentable subject matter. So the case was eventually brought to the Supreme Court, and it was held that this gentleman's bacteria was indeed patentable. The issue wasn't whether or not the bacteria was living or non-living, because living things can't be patentable, but rather, or living organisms that are naturally occurring cannot be patentable, but rather if the invention had markedly different characteristics than that which would have occurred naturally. In other words, as a modified bacteria, it was not something you would find in nature, So it was found that it would be completely different, and therefore a patent was issued and allowed for this particular genetically modified organism. Then later on, and many of you may have heard about this, the 2013 Supreme Court case ruling happened, and this was myriad genetics. This were the BRCA genes. And there was a big spree of discussion and debates over, can someone own my genes? And in this court case, it was really interesting because there had been thousands of patents issued on genes that people had identified. A lot in the cancer space, but in most spaces in general. And it was ultimately found by the Supreme Court that even though some of these genes may be mutated in the human, they were still naturally occurring and therefore were not patentable subject matter. So as a result of this ruling, there were over 4,000 patents that were immediately nullified because they were patents dealing with genes that had been identified by humans that were naturally occurring. However, the Supreme Court did indeed rule that manipulated DNA or DNA that was changed outside of the body could be the subject of patents. And these cases in general have really honed and identified where biotech patents now can be granted. Biomarkers are also a very interesting area. One cannot patent the biomarker itself, but the use of the biomarker and how it's used in treating a patient can become patentable subject matter.
Terrific. So, as we talk about a little more specifically, that is, about intellectual property in the world of academic medicine, there are some differences from what we do, say, versus what Silicon Valley does, for example. So, could you talk a little bit more then about how intellectual property works specifically in the world of academic medicine in the university setting?
Sure, there is certainly a difference. In the world of academia, we're often in a publish or perish state, so we understand that faculty do have to publish their data and their research at a very early stage, whereas in industry, they're going to be able to hold on to that information. They don't need to publish early. So typically in an academic setting, we're filing patents at a much earlier stage of the technology. So we may just have cell culture data, something that we're still trying to figure out even the mechanism of, but we know that something's happening. My drug or my X is inhibiting cancer cell growth in a tissue culture plate. In the industry, they may hold off a little from filing that patent. And the idea behind that is if they can keep that secret, they want to extend the patent term as long as they possibly can on the back end so that they can collect revenues for the longest amount of time. So they're not going to be publishing, so they can sort of hedge their bets and wait until the technology is better developed before they file any patent applications.
So along these same lines, we have faculty members listening to this broadcast who may be asking themselves, when should I consider filing a patent for my research or my discovery? And if I do decide to do that, how should I proceed and who should I contact?
The first thing that you do before you even publish, before you mention it to any colleagues, before you present your data at any conference, even submitting an abstract or blogging or tweeting about your research, you should contact your technology transfer office. Most universities have this office. You can reach out to a person like me. The title is usually licensing manager, licensing associate, or technology manager, and they can help you go through that process. It is important, and I can't understate this or overstate it enough, that you reach out very, very early in the process. I often, when I talk to faculty members, tell them I'd rather say we're not ready yet than have missed an opportunity. And why this is important is because if you should publish about your invention, say you publish a composition of matter, and you haven't filed a patent application yet, that excludes you from being able to file a patent in most jurisdictions in the world. Now, the United States does have a 12-year grace period from that publication. If it's your publication and you're the inventor on the patent application, you can still get United States protection within that 1-year grace period from that first public disclosure. But again, when we're talking about pharmaceuticals and devices, something that has a worldwide application, it's really important that we think about interacting with your tech transfer office very early before you disclose it in any way.
And there are circumstances when we want to, of course, be good corporate citizens or good university citizens in our case. But there are circumstances when a faculty member may want to consider filing for a patent independent of their university. But of course, we want to understand what the guardrails are that govern our ability to do that or might preclude us from doing it. Obviously, taking the wrong path in that situation can lead to legal problems and employment problems and all kinds of other issues. So could you tell us a little bit more about when it might be appropriate for faculty members to file for a patent independent of their university or employer, and when they really need to stay within those organizations?
Certainly. So most organizations will have a policy on invention and works, and it's important that you look at this and know what this is. For example, at the University of South Florida, our policy is 0300, and it very clearly describes when a faculty member, a staff member, or volunteer, and possibly even a student need to disclose any inventions to the tech transfer office. Often, the basic fundamental is, was this funded by university funds, those that have come from the NIH or the state? If so, then we're going to have an obligation to disclose that, and also to disclose to the funding agency that we're filing a patent application if we do.
And although we're not talking specifically about copyright so much today, I would assume that the same logic applies to copyrights as well, correct?
It does in most regards. So different institutions will have different policies on, say, textbooks. If a faculty member writes a textbook for their class, the university or the institution may or may not take an ownership interest. That's going to be more specific to the institution. If it's a copyright, for example, we have here a copyright Parkinson's diary. That patients that have Parkinson's disease and are going through clinical trials, they will utilize those to tell when they're on and off with symptoms. And this is a copyright that was definitely within the scope of the employ of the author, and it's frequently used in clinical trials for Parkinson's disease. So this was something that had to be disclosed to the university, and we actually license this on a regular basis to companies that are performing clinical trials.
So once a faculty member has decided, okay, I think I want to go for a patent now, what are the requirements for and the steps necessary to secure a patent?
So the first step would be to contact your tech transfer office. In the tech transfer office, they will then perform what's called a prior art search. To get a patent, the invention has to be novel and it has to have utility. So the first step would be to determine if your invention is novel. So we have interns at USF, and most institutions utilize the same sort of technique that will scour databases and look for any technologies that are related. Those reports are then made, licensing managers or patent agents will review those, and then discuss with the inventor how their invention is the same or is different from what's out in the prior art or anything that's been done before. So prior art can be patents, publications, blogs, tweets, any form of public disclosure. Once that's completed, if it's deemed that the subject matter does not have prior art, we'll also look, is the subject matter patentable subject matter? If the subject matter is indeed patentable, then we can start the patent application process. One of two things can happen. You can file a provisional patent application in the United States, or you can go ahead and file a utility application. Oftentimes in academic medicine, we're filing provisional applications. This is a 1-year application. It's never really reviewed by the patent office. It's not examined for prosecution. And what it does is it puts your foot in the door and gives a stamp date of the time you invented this in the U.S. Patent and Trademark Office. So in academic medicine, this is a very important avenue because it can give the inventors the ability to go and present their work before it's quite ready for that final utility application. The utility application is the application that is reviewed by the patent examiner and will eventually either be denied or become the patent itself. We also have the option in the United States of filing a worldwide patent or a PCT through the Patent Cooperation Treaty. And that can give rights in, say, Europe, Japan, Asia, South America, many countries.
So there are circumstances when it would be unwise to file a patent or perhaps a waste of time. You've alluded to some of them. But under what circumstances should a faculty member definitely not file for a patent?
The Technology Transfer Office will probably advise not filing a patent if the prior art is very robust. For example, in the catheter space, there are so many different kinds of catheters that are out on the market or have been patented, some that even have not been patented, but that space is very, very crowded, and the likelihood of obtaining a patent is very minimal. And the patent office will always have to think of the fiduciary responsibility to either the state if they're a public institution or to the college or university itself if they're private. So it is quite expensive. It can be up to $35,000, $50,000 just for a U.S. patent to be granted. So when the prior art's very thick, we really have a conversation on whether or not it's really worthwhile to proceed if we don't think anything of significance will issue. There may be times when an inventor doesn't think he has or doesn't think they have any competitors. They don't think they'll be scooped. Maybe they're making a brand new molecule and they really want to take the time and develop it, much like industry would. And so we can keep everything kind of quiet if they're not working on a particular grant that makes them publish, or they're in a situation where they can keep that sort of close to the vest for a while. We might want to take that opportunity and do that to, again, extend the amount of time that would have commercial appeal to potential investors or companies.
And overall, apart from the things we've already discussed, what do you think are the clearest advantages and clearest disadvantages of having a patent in academic medicine?
If the goal is to translate the technology to the public, it's imperative that a patent be granted. It's a very expensive, long road through clinical trials and to get FDA approval on medications and therapeutics, as we know. So without that ability to have a certain time or monopoly for the market, there's going to be very little investment that would happen. So it's just part of the system that extensive investment's required. For people to make that investment, they need to have that knowledge that they'll get some return on their investment.
And I would just like to add, alluding back to what we talked about before with dynamic tension in the academic sector versus the corporate sector vis-a-vis patents, I have seen circumstances in which faculty decided they wanted to apply for a patent on a discovery that they had been working on in the laboratory. However, they had not yet reached the point they could monetize it. They wanted to do additional research, but they were caught between a rock and hard place because in order to continue to get grant funding to underwrite further development of their idea, they needed to publish their findings from the initial studies that outlined the discovery and publicize them. By the same token, doing that might alert their competitors to do a similar project and obtain a patent. Therefore, they were left in the difficult situation of either not publicizing and potentially losing grant funding and therefore not being able to pursue further development of the idea, but having a patent in case it did ultimately work, as opposed to not having a patent and being able to freely share their discovery with the academic community, as has happened traditionally throughout most of recent academic history. So I would say, from having seen some of these situations, that a faculty member who is going to think about a patent should also consider that aspect if they want to be in a situation where they have to keep a lot of their work under wraps, and consider the potential negative consequences of doing that versus whatever advantages they think might come from a patent. I think the bang has to be pretty big, and I think you have to have a realistic chance of someday monetizing and actually being able to sell the idea that you want to get a patent on. And I think that piece probably can best be decided in collaboration with our business partners and places like the Technology Transfer Office. One of the assessments I think that needs to happen is this ever really going to be something that anyone would buy or not? And if not, I'm not sure that the patent really has an important place.
Sure, definitely. And that is one of the things that most technology transfer offices will also look at during that initial phase following the disclosure before patenting is what's the market. So in our office, we call it a market analysis. Also, there is a requirement by the federal government. If you receive federal funding, we have to report any of those innovations and patent filings that we make to those agencies. For instance, if you get a grant from the NIH, once something's disclosed to our office and we decide to file a patent, we're reporting that back. These institutions are wanting to monitor the development of technologies that they're funding. And as a result of an act that occurred in 1980, the Bayh-Dole Act, it actually encourages universities to file patents and commercialize technologies that are federally funded.
So we live in an age of really dramatic and rapid transformation of everything. It's been kind of a fascinating journey, particularly as the 21st century has really taken off. We see huge advances in technology, and of course in medicine, we're seeing dramatic advances in therapeutics, particularly in neurology, thanks to advances in neuroscience and many of the tools at our disposal to treat the diseases that we treat. In the world of intellectual property in general, I think there's also been really dramatic change over the last 20 or 30 years, particularly as the digital world has come into its own. So could you maybe in a broader sense now, as we begin to wind down, talk about what the future of intellectual property in general might be? Will require some speculation on your part perhaps, and particularly the future of intellectual property in academic medicine.
Sure. I think in academic medicine, we're going to continue to see an increase in patenting and technology commercialization. All indications point that way. The large pharma companies are partnering with university startups to help develop these drugs. Strategic partnerships are becoming more and more common. It really is the only way to move technologies out of the academic medical institutions into the hands of the physicians that are prescribing the medications and using the diagnostics and providing the therapeutics.
Thank you again for being with us. It's been a fascinating discussion.
Thank you.
That was Dr. Clifton Gooch, Professor and Chair of Neurology at the Morsani College of Medicine at the University of South Florida, speaking with Dr. Terry Hunter, Senior Licensing Manager of Technology Transfer at the University of South Florida Office of Research and Innovation. For ANA Investigates, I'm Adeline Goss.
This has been an episode of ANA Investigates, the official podcast of the American Neurological Association. Thanks for joining us. To learn more about today's program and to access more of the incredible content produced by the ANA, check out myana.org. Adeline Goss is our host. Our producers are Romer Giucaden, Adeline Goss, Michael Halstead, Megan Ritchie, and Jim Sigler. Our editor is Jen Hurley. If you'd like to learn more about receiving CME credit for listening to ANA Investigates, visit myana.org and navigate to ANA Investigates under the Education tab. For more information not covered in today's program, check out the official summary of this episode, published in one of the ANA's journals, the Annals of Neurology or the Annals of Clinical and Translational Neurology. Copyright, the American Neurological Association.